I have put exhibit number 7 up on the screen. Do you recognize that?
Yes, that's my old TikTok account.
That was a TikTok account that you had during the summer of 2020, correct?
Yes.
And it says your name on there, Kyle?
Yes.
Your username on TikTok was 4 Doors More Whores?
Yes.
And that's a picture of you there with your AR-15, correct?
Yes.
And underneath that, you have put on your profile the phrase, bruh, B-R-U-H, I'm just trying, T-R-Y-N-A, be famous. Is that correct?
Yes.
You're the one who wrote that?
Yes.
So I was planning on covering something different on this channel than the Kyle Rittenhouse trial or bad reporting about the Kyle Rittenhouse trial. I really wanted to move on, at least for the interim, and wait it out until the verdict, unless, of course, something major happened. And then I woke up in the morning, scheduled my video for a premiere, went on Twitter, and realized that Kyle Rittenhouse, the man himself, was testifying on the stand, something that I thought was a near impossibility. And the reason why I thought that, and the reason why I mentioned that at the end of my Gross Croots video, was because this seemed totally unnecessary and an obvious blunder if it were to happen by the defense. You see, there's nothing noble about testifying in your own trial, especially when you're already in the lead, when you already have that gold medal of the acquittal looming based on the previous star witness completely falling apart on the stand. So no way did I think that this was a possibility, but it happened. And we're going to talk about it. Also, I said noble and gold, noble gold transition. Is your entire life savings in the stock market despite all the warning signs of upcoming danger, inflation, a supply chain crisis, all these other problems that seem to be just a couple months away? Well, you guys can do a lot worse than just calling Noble Gold Investments and talking to them about the tax advantages and the security of putting some of your stuff in precious metals. If you contact Noble Gold, you can learn about some of the tax advantages of a precious metals IRA, and of course there's a gift for this month. It's an America the Beautiful 5-ounce silver coin. It looks like a giant quarter. I actually really like this thing, so consider opening a thing. The website is noblegoldinvestments.com. My custom URL is in the pinned comment and at the top of the description, or you can call them at 877-646-5347. That's 877-646-5347. Now look, there's a lot to talk about in this testimony, and the reason why is because there is a ton of testimony. There's the original examination by the defense because Kyle Rittenhouse is a witness for the defense. Obviously, he's testifying in his own defense. I don't even know why I'm explaining this to you, but honestly, the way the media has been covering the court proceedings, I probably have to explain it as if I'm talking to a 4-year-old child because that's the level of understanding of court proceedings that mainstream media journalists appear to have related to this case. Now, in general, although there are some very specific asterisks to what I'm going to say as a rule, I am not that concerned about the original examination. What I'm far more concerned with is cross-examination, because obviously you prepare with your lawyers. You go over testimony. They ask you questions that they are going to ask you in a practice run, and they try to ask you questions they think the prosecution is going to ask you. And the cross-examination is typically where it's at, because that's how your story stands up to scrutiny, because it's all well and good to answer questions in front of a friendly interviewer, basically, but when you're being challenged and put on the spot and being questioned intensely, that's when we see how well your story stands up to scrutiny. Now, this trial has been a crazy anomaly because during examination, we've seen amazing clips where the prosecution's witness completely undermined the prosecution's case, and we've seen epic cross-examination like that of Gage Grosskreutz. We dedicated a whole video to that because it was crazy how fast this case imploded. Now, for Kyle Rittenhouse's story, it's more traditional. The examination itself is not that interesting. There was a moment that a lot of people found very powerful where Kyle actually broke down under the weight of the fact that he did take 2 human lives, and even though this was in self-defense, obviously this was not the outcome that he wanted. The only people who believe that are crazy left-wingers who want to get him because gun bad or Rittenhouse bad or whatever.
And there were there were 3 people right there.
Take a deep breath, Kyle.
That's what I... That's what I run.
We're going to just take time for our break anyway. You can just relax for a minute, sir. We're going to take a break about 10 minutes, and please don't talk about the case during the break.
Now look, that's emotional. I think it's important to remember and remind ourselves that Kyle was 17 at the time, and he's been demonized by the mainstream media for over a year, by the online left-wing media for over a year, and he hasn't really had the chance to go out publicly and tell his side of the story, because on the advice of his counsel, which is good advice, you should not do that. We saw how that worked out for Gage Grosskreutz, who was just talking nonstop about the case when he had to stand up to scrutiny. But that's really not the interesting part. There's 2 interesting components of this, and they are both involved in the cross-examination. And I struggled to decide how I want to cover this story, whether I want to go over the judge thing with the cross-examination and the constitutional violations and the violations of the judge's orders as established for this trial, or just the cross-examination, but I've decided to go with the former first because I said it first. So, what went down in this part of the cross-examination is incredibly crucial because it builds on things that we've covered in the trial before. Now, you guys have seen the clips. Don't get brazen with me.
That was before the
Don't
defense testimony.
get brazen with me.
Is a meme on the internet right now.
You've also had the opportunity to listen to the testimony of all 30-some witnesses that have testified in this trial so far, correct?
Yes.
And after all of that, now you are telling us your side of the story, correct?
Correct.
I'm going to ask you folks to go in the library for just a second. Please don't talk about the case. You need to account for this.
Your Honor, I don't want to jury here. He's commenting on my client's right to remain silent.
No, Your Honor. I am making the point that after hearing everything in the case, now he's tailoring his story to what has already been introduced.
The problem is, this is a grave constitutional violation for you to talk about the defendant's silence. And that is, and you're right on the borderline, and you may be over, but it better stop.
But it's important to understand the rules in question so you guys can have an understanding of why the judge came after the prosecutor so harshly. And we also have to talk about the overall context of the media coverage and how, despite what the left-wing media says and left-wing people on Twitter say, the judge is actually leaning harder toward the prosecution than he should because they have no case and they're openly violating rules, possibly in the hopes of getting a mistrial after witness torpedoed their case. Now, the first thing, and this is the most obvious, is the constitutional violation. The fact that the prosecutor decided to go after Kyle Rittenhouse for not talking about the case before he came into trial. Obviously, you have a Fifth Amendment right not to bear witness against yourself. You have no obligation to do interviews with the police. You have no obligation to do interviews with prosecutors. You have no obligation to do interviews on TV, nor should you if you are ever arrested, put on trial, or you're going to be asked to do TV interviews. You should always ask for a lawyer because, as that old adage goes, you will never be able to talk your way out of trouble, but you definitely can talk your way into trouble. So get a lawyer. Ask them for counsel. Don't worry about appearing more guilty because it is literally a constitutional violation for the prosecutor to deem you asking for a lawyer as evidence of your guilt, which is insane for this prosecutor to actually do that during the course of this trial.
Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney, and he knows better.
Now, every lawyer knows this rule. Good lawyers, bad lawyers, terrible lawyers, new lawyers, old lawyers, they all understand this because this is a basic constitutional principle. It applies in every state. You don't even have to do the whole, what about this jurisdiction or that jurisdiction? It is that fundamental in our system. You cannot try to impeach a witness based on the fact that they exercise their constitutional rights, which, by the way, are the smartest thing to do. But this lawyer did this, which led to a lot of people to speculate that maybe they were trying to get a mistrial so that they can have a retrial because they failed so hard in this trial. This is one of the reasons why the judge was so angry at them, because in reality, the defense's motion for a mistrial with extreme prejudice was a valid motion that could have been granted just on this factor.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
their motion.
We have not filed any
me.
motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed another acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your arguments of record, my comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Now, the next thing is less fundamental in terms of constitutional law, but it is pretty fundamental in American common law, and you will find similar restrictions in all the states and federal courts. And this was trying to bring up Kyle Rittenhouse's past to basically make the association that he was violent or one way in one situation, therefore we can apply this to another situation. And I believe the judge referred to this as propensity evidence, and we actually went over the disallowing of this in the pretrial hearing. Now check out that video if you want to see me review why the judge made those individual decisions in a longer format.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record, if I could, without being interrupted, if that's okay. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior involving the same gun, where he is threatening to use that gun to protect property. It
He
goes.
didn't have the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. I want.
May I
look,
respond to what you just said, Your Honor? I'd like to respond to what you just said.
The court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop. And he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one.
But the long and short of that video is essentially this. You cannot introduce, it is considered propensity evidence to do so, past behavior that is not related in a non-similar situation in order to smear the defendant in a way to say that they were violent or they were angry in this unrelated situation. Therefore, under these completely different circumstances, this person is probably violent or did the crime because of those past actions. This is clear and obvious. This should have not even been attempted to be admitted in a court of law, and it's absolutely ridiculous.
Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense, that's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you.
On top of that, the same ruling applied to the defense when they tried to introduce the nature of the felony convictions and the past criminal histories of all three people who were shot by Kyle Rittenhouse. Now, we all know Joseph Rosenbaum had serious felony convictions for crimes that involved 5 young boys, and he was on that special registry if you guys don't get where I'm going with this. But Anthony Huber, the person with the skateboard, actually has some domestic violence charges and I believe convictions in his past. And Grosskreutz actually had his firearms permit suspended due to the fact that he was arrested for an armed burglary. So these people all have criminal histories that are all being barred from the court because of this propensity evidence rule, because all of those felonies or all of those charges, not all of them were felonies, let me be clear about that, have nothing to do with the mindset and their different circumstances and all the same justifications for why the evidence that was not allowed, that the prosecutor tried to bring up anyway against the judge's previous ruling, is ultimately not allowable. It's the same rules, they're being applied. Honestly, the existence of this rule helps the prosecution because their nonsense about Kyle Rittenhouse watching people loot, talking some nonsense, and then eventually calling the police wouldn't have convinced anybody anyway. But the thing in Rosenbaum's history and the things in Huber's history and the things in Grosskruetz's history are absolutely the kind of things that would impeach a witness and thus lead to an improper ruling due to the fact that improper things are being considered. So this was a totally fair ruling. A lot of people were spazzing out like, oh, how could the judge not do that? He must be in the tank for Rittenhouse. He's working for Rittenhouse. All of these conspiratorial nonsense, even though when you accept this rule's application in its totality, it is clearly something that helps the prosecution more than the defense. And the prosecution knew that what they were doing was wrong. The judge did not believe them. He knew that they were lying when they were pretending like it was all well and good. They tried to override the decision and thus the anger from the judge.
I had done some research, and at this point, the defense is going to be making a motion for a mistrial. However, that motion is going to be requested with prejudice. I'm aware that the court's aware that normally a defense motion for a mistrial does not preclude a retrial. I understand that. There are exceptions to that, however. And the case that I am drawing this from is Day versus State. It's 76 with 2nd 588. And what it says is, an exception to this rule exists where a defendant's motion is necessitated by prosecutorial impropriety designed to avoid an acquittal.
But the second reason, in my opinion, from my analysis of how the judge has responded to media coverage, that the judge was so irate with the prosecution, other than the fact that they blatantly disrespected him in his own courtroom, and they violated constitutional procedures that they knew about. Both of these moves were done intentionally, in my mind, by the prosecution as a way to rebuff the judge and challenge the defense and make a stand for the media, is because this does give grounds for a mistrial with prejudice. But the judge cannot politically, in terms of the media and all the people that are attacking him, grant this motion even though it is completely valid, because that will confirm and cement the narrative that he was on the side of Rittenhouse. Unfortunately, our media are basically illiterate when it comes to legal issues, so even though had this happened in a case where the defendant was left-wing, all the constitutional and actual law people on the left would be talking about this and how it should be dismissed. They're not doing so now, so the media is just running wild with their speculation about this guy being a right-winger, and thus he's being attacked for this decision, even though not granting that mistrial with prejudice is something that aids the prosecution. So what's actually happening is the left is complaining, they're undermining our institutions, our judges, when they're being fair, in order to get them to tilt slightly towards them. Now, I don't think that this is going to help the prosecution's case overall, the evidence is so overwhelming in Kyle's favor, but I just want to give you a perspective on reality, what's actually happening in the courtroom, and the actual impact of the media influence on the courtroom, because the left-wing media will tell you the exact opposite, because they're actively trying to put pressure on the judge and alter these court proceedings, because they don't believe in a fair and just system. They believe in exerting their power over any system in order to get the outcome that they like.
Here on the sidelines, just
Well, you...
yeah, I had made a ruling that the evidence wasn't coming in, and you decided that it was.
If I could just respond to that briefly, Your Honor, I was about to say, I did not interpret your ruling as an absolute... We've had 3 state motions in limine. There was one in which we asked the court to introduce evidence that the defendant was at Pudgy's bar with Proud Boys, and you were clear, that is not coming in. There was...
You know, don't get into other subjects. Come on, what you're telling me, you're an experienced trial attorney, and you're telling me that when the judge says, I'm excluding this, you just to take it upon yourself to put it in because you think that you've found a way around it? Come on.
If I may finish, Your Honor, I was about to say that your ruling on our 3 motions and other acts motions was, there were some gradations there. That you were clear that some things were absolutely out, and then you left the door open on other things.
No.
So I saw that distinction, and I thought to myself, clearly I know this is out, but you left the door open on other things. So I didn't interpret your ruling as this is absolutely never coming in, and I have practiced before you, Your Honor. I have filed other acts motions before you. Your practice oftentimes is to reserve ruling on those until you see the evidence. And I think you even said something to that effect at our motion.
I undoubtedly did.
So I thought, this is my good faith explanation to you, and if you want to yell at me, you can. My good faith feeling this morning after watching that testimony was you had left the door open a little bit, now we had something new, and I was going to probe it.
I don't believe you. There better not be another incident. I'll take the motion under advisement. And you can respond. When you say that you were acting in good faith, I don't believe that, okay? Let's proceed. Everybody in good faith.
Now that we got the constitutional issue under rest, now that we got the mistrial issue under rest, I want to move on to what actually occurred in cross-examination and why I believe that Kyle Rittenhouse should not have taken the stand. Because one of the tricks that I noticed that the prosecution was doing when describing Rittenhouse's gun is that he would always say AR-15, AR-15, AR-15. If you watch this, you can't unnotice it once you first realize what's going on. And the reason he did this is because this firearm is the most demonized gun in the country, and he's hoping that him repeatedly labeling it the most dangerous gun according to the media will convince people that Kyle Rittenhouse was carrying an even more dangerous weapon.
And you brought your AR-15 along. The AR-15, because you've got an AR-15 aimed at him. That's a handgun, right?
Yes.
And you have an AR-15.
Now, while that might not seem ridiculous on its face, it's ridiculous according to the numbers. If you look at the number of people who are murdered or homicides by handgun, then the number's around 10,000. If you look at the number of rifles total, not just AR-15s, then you're about 250 a year. Obviously, the concealability, the easy access, the fact that they're cheaper of pistols makes them, on effect, more dangerous, even if there's more technical proficiency in a rifle. Rifles are typically easier to aim. I know this from being at a shooting range once. So all of you gun dorks that are out there that are going to leave me comments down in the comments about how I didn't get whatever, I don't care. In general, the things that I'm saying are correct. If you want to correct them, then please leave your comment on somebody else's YouTube channel, because that will aid me in not having to read that nonsense. Now, the next reason I didn't want Rittenhouse to testify is because you don't do things that you are supposed to do when you're losing when you're winning. Let's say it's a tie game, top of the 9th inning, you have a person up at the plate, 2 men on, hits a 3-run homer, you got a 3-run lead. Your star player is on the bench, not feeling well, recovering from an injury. You probably would have sent him up to the plate if that other guy had walked, because this is your star player and maybe they get the at-bat and maybe you guys can get the runs that you need. But you don't send him up to pinch hit in this situation, because what if you send him up to pinch hit in this meaningless at-bat and he gets injured further, and then you don't have them for the rest of the season or the rest of the series or so on. Again, you gotta act like you're winning when you're winning, not play like you're losing. And there is damage to Rittenhouse. He would have had to have been perfect, stellar in this for him to improve the way the case was going, because the case was so overwhelmingly in the defense's favor. And he wasn't perfect. There were points where he stumbled. I don't think he did anything or said anything that would lead to a conviction, but he was able to be hit over and over again with AR-15, 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 and he was questioned so much that eventually he wasn't standing up to scrutiny. That's just how it was happening. His answers were getting slower, which gave the appearance of dishonesty, even though dishonesty was not there.
Correct?
He does kick me, yes.
And you fire 2 shots directly at him with your AR-15, correct?
Yes.
You intended to hit him with those bullets, correct?
I intended for him. Yes.
At that close range, it's a miracle that you missed, right?
I don't know.
You intended to kill him with those shots, didn't you?
No.
Did you even care whether or not those 2 rounds were going to kill him?
I didn't want to have to kill anybody that night.
In this moment, you're making a deliberate decision to pull the trigger twice, correct?
Yes.
That wasn't an accident. That was your conscious decision, wasn't it?
Yes.
And you're firing an AR-15 at close range to this individual, correct?
Yes.
And you knew full well that if you hit him with 1 or both of those bullets, it could kill him, right?
There's that possibility.
Again, I've laid out the case for Kyle Rittenhouse's innocence, not Kyle Rittenhouse to be found not guilty, but his innocence under Wisconsin state law since day one. So don't think I'm not on that camp, don't think I'm abandoning this situation or anything like that, but I want you to move beyond the idea that you know he's innocent based on the evidence that you've seen to how a jury is going to perceive what appears to be a nervous defendant that didn't need to be on the stand in the first place. Now, with that being said, even though I do think it was in fact an error to put Kyle Rittenhouse on the stand because cross-examination can be difficult, the prosecution really didn't help themselves because they dragged out this cross-examination for so long that it actually got incredibly boring. And if you think about it, the things that were exciting about this trial were the judge going in on the prosecutor, the defense attorney getting angry and the back and forth and all of that. All those memeable moments that make people think that the judge is the biggest Chad ever or all that nonsense that's put out on the internet. But the jury's not present for that. That's all stuff outside the purview of the jury. So imagine you just saw the most boringest part for hours and hours and hours and never got to it. There was a point where the judge actually told the prosecutor to pick it up because he was asking him the same questions over and over again, multiple different times, and they weren't relevant.
You have also sat here through 8 days of trial, correct?
Yes.
And you've had the opportunity to watch all of the videos that have been played in this trial?
Yes.
Sir, if you could please let me finish my question before answering. And I will do my best to let you finish your answer before I go on to the next question. Fair?
Yes.
Also, the lead prosecutor has an attitude problem. I don't know what he was thinking. We talked about the body language of the assistant DA earlier on when he was literally face palming after a star witness crashed and burned. But this guy throws nonstop attitude at Kyle Rittenhouse. He's disrespecting him, and he's just not likable in any way. If this trial is based on likability, which, spoiler alert, trials are also in part based on likability, he's decided to take a knee on this issue and concede it. There was a point where he called Kyle out for not looking directly at him, which was nonsensical because he said he was looking at his own attorneys, but his attorney was behind him, which his attorneys objected to because that was a ridiculous thing to say. But it's all this attitude about answer my question directly, like getting after him, and the judge wasn't having it. I don't think the jury was having it, and it was just not a good look for the prosecution in this case.
Use it to protect your house, correct?
Correct.
You picked it out because it looked cool.
I thought it looked cool. Guess that's the reason, yes.
It resembled the types of weapons that are used in first-person shooter video games, correct?
I don't really play first-person shooter video games. I have, but I believe there's a variety of guns, including shotguns, pistols. There's guns in video games that resemble all guns.
Isn't it true when you would hang out with Dominic Black, you'd play Call of Duty and other first-person shooter video games?
Sometimes.
And those are games in which you use weapons like AR-15s to pretty much shoot anybody who comes at you, correct?
It's a video game where two players are playing together. I don't really understand the meaning of your question, to be honest.
Isn't one of the things people do in these video games try and kill everyone else with your guns?
Yeah, in the video game, it's just a video game. It's not real life.
There's also stupid questions that were asked, and I'm not talking about stupid in that they were boring or they go without saying, but questions that the prosecution asked in order to undermine Kyle that they didn't really understand the answer to. At one point, Kyle called Kenosha his community, and the prosecutor wanted to challenge that because he's like, you live in Illinois. Even though we all know, believe me, we all know that Kyle Rittenhouse lived 15 minutes away on the border of Illinois. One of his closest friends who was dating his sister lived in Kenosha, Wisconsin, and his dad lives in Kenosha, Wisconsin. He still went with this to undermine the idea that Kyle has a connection to this area, to which Kyle responded in one of his better responses under cross-examination. My dad lives here. But fundamentally, where this all boiled down to was the prosecution trying to establish intent from Rittenhouse to do harm. And the way that they tried to do it is absolutely ridiculous, but unfortunately, Kyle did not rebut it in the way that he should have, which would have ended the case even further.
And you brought your AR-15 along?
Yes,
Why?
because it was with me already.
Yeah, but you'd taken it off earlier when you were treating someone. You gave it to Joanne Fiedler, right?
Yes,
So you know how to take it off, don't you?
yes,
And you can make a choice on your own whether or not to go armed with it or whether to give it to the person who is the lawful owner of it on that date, Dominic Black. Correct?
I didn't take my rifle off there because there was nobody I could hand it to. And when I took it off to hand it to Joanne Fiedler, I was in a safe spot in that corner of the building where there were people protecting me at that time right there. When I went to go to the car source number 3 to put out the fires, there was nobody I could hand my rifle to that could protect me while I'm providing first aid to somebody.
But you still knew you had it.
My rifle, yes.
You still knew you had it strapped around your body,
Yes.
and you made a conscious decision to bring it along, right?
Yes.
Why?
Yes, to answer.
He gave an answer about how he already had it, and we
Go ahead.
go through on that. So,
You know, did you hear the question?
I did, but I don't really understand what...
well, was it simply that, well, I've already got it strapped on, so I might as well bring it along? Is that what you're telling us? You decided to bring along the AR-15 because, well, I've already got it? Is that your answer?
I don't think I was thinking, like, hey, I'm going to take my rifle off. I wouldn't have because there was people around that could have stolen my gun, and I didn't. I didn't take my rifle off because I was going there alone. I was going to be running there alone, and I didn't take it off because no one else was there to protect me as I was going there, so that's why I brought it.
For protection.
Yes.
You brought it along down there because you felt like you would need to protect yourself against someone else harming you. Correct?
If that would have happened, I would have protected myself, but I didn't think I was going to be attacked and ambushed.
But you just said you had it for protection. What were you expecting you would need protection from?
I thought we had covered much of this before.
I'm specifically focusing in on the time period where he is heading down to the 63rd Street car source. I have not asked him about this yet, Your Honor.
So to give you some background on this, the district attorney had asked Kyle whether or not he viewed the crowd as hostile towards him or his group as a whole. And Kyle basically said, not really. There were some instances, but other than those isolated instances, he thought he was there for everybody and he was willing to help everybody and he didn't think people were that hostile towards him. Now, Then Kyle Rittenhouse said when he ran over to the car thing, he ran with his gun, which was strapped to him, and the reason he did this was for protection. Now, the DA was trying to set him up by saying, if you didn't think the crowd was hostile, why did you have this gun for protection unless you expected to use this gun? He was basically making the argument that we've heard from the left wing time and time again, that Kyle carried the gun there in order to instigate a fight because he wanted to shoot people. This is a dumb argument. This is ridiculous. But Kyle didn't rebut this argument in the way that he should have. He just said, I carried it for my protection and I wasn't expecting to use it and I didn't intend to use it, which is true, but it's not the best response. So essentially this argument is the equivalent of interviewing somebody after they got into a car accident and then questioning them on why they were wearing their seatbelt. And they would say that they were wearing the seatbelt for their own protection, for their own safety. And then you make the leap in your head that somehow them wearing their seatbelt, that precaution, is an act of them expecting an accident, and therefore they are culpable in that accident. We would not accept this logic under any other circumstances that are similar, but the prosecution was trying to apply it in this situation where it didn't fit. But Kyle Rittenhouse did not say, and I was screaming at my computer, my TV, at my phone, yes, the trial was long, this line of questioning was that long, to just say it was for potential risk. I was not expecting to get into an encounter, but just in case, I wanted to have something to protect him with. Now, he did say at one point there was nobody for him to hand the gun to when the prosecution was like, why didn't you hand the gun like you did before? But obviously, what he needed to say is that he was protecting himself from potential risk. He wasn't expecting an encounter. He wasn't looking for an encounter. He wasn't looking for a fight or anything like that. He was just protecting himself from potential risk, which, by the way, that's what guns are for.
When you decided to bring your AR-15 loaded with 30 rounds down to the 63rd Street car source location, what did you think you needed protection against?
I didn't really think I was going to have to protect myself.
You told us just now you brought it along for protection.
I did, but I didn't think I was going to need to protect myself.
You brought it along for protection, but you didn't think you needed protection?
That's not what he said. Objection.
I'm trying to clarify the two different answers that I think he just gave, Your Honor.
Well, go ahead. Do
you understand the question?
Not really.
I asked you why you brought the gun. You said you needed it for protection. I said, protection against what? You said you didn't think you needed protection. I'm confused. Can you help me understand why you're telling us you needed a gun for protection, but you didn't think you needed protection?
I brought the gun for my protection, but what I was saying is I didn't think I would have to use the gun and end up defending myself.
Now look, you might not think this is a big deal, you might not think it's significant, and I understand that, but you have to understand that you're not on the jury. You have access to the background of all these different people, and obviously you're watching this channel in part because you have a perspective. The jury is supposed to look at only what is introduced in the court of law, and if the prosecution is pressing him over and over again and trying to portray him carrying a gun, even though the law does not in line with what the prosecution is saying, as an act of aggression in and of itself, and Kyle doesn't rebut that properly.
Did that even factor into your mind at that point? Did you even care whether you were going to kill him or not?
I didn't want to have to kill anybody. I was being attacked. That's why I shot him. Shot at him.
You shot at him with the intent of hitting him and killing him, correct?
I didn't want to kill anybody.
Then why are you shooting at someone with an AR-15 at close range if you don't want to kill him?
Because he's attacking me, and he's stomping my face in, jumping and kicking my face in.
Right.
No.
You didn't see a knife?
No.
You didn't see a bat?
No.
You didn't see a club?
No.
All he's got is the skateboard, right?
That he's hit me in the head with twice, yes.
Okay. And you intended to pull the trigger at that moment with your AR-15, correct?
Yes.
That wasn't an accident.
No.
That was your deliberate decision, correct?
Yes.
And you knew that the way that gun was positioned, you were going to fire that bullet right into his chest.
Then there's the potential for this lack of clarity of language from Rittenhouse, the lack of precision in his responses to the prosecution, leading to a conviction. It is more likely that Kyle Rittenhouse will be convicted than before he testified, now that he has testified based on his testimony and how the cross-examination worked for the prosecution. If I were to put the odds of conviction of Kyle Rittenhouse before the testimony, I would say it would be about 0.5%, but now it's about 0.8%. So that is a move. We're getting close to that 1% possibility. Now, I don't think this moved the needle a lot, but again, it depends on how all the other experts stand up to cross-examination. We've seen the defense do great work under cross-examination, but again, Kyle Rittenhouse testifying in his own words is something that the jury is going to be paying attention to. So if he doesn't look good, if he's not precise, if he doesn't clarify something, if he misspeaks, and that's what the jury takes home with them into the deliberation room, then that could spell trouble for Kyle Rittenhouse. Now, with that being said, there is one moment that I think is incredibly instructive of why it's good not to declare war on the judge like the prosecution is. And that was this exchange right here.
At a moment here when he is crouched in front of you with his hands in the air, correct?
Yes.
Your gun is pointed at him, isn't it?
It's pointed downward towards his feet.
It's pointed at his body, some part of his body, correct?
Yes.
And he's no threat to you at this moment, is he?
Objection, Your Honor. He's standing in front of him with a gun.
That's an argument you can make. I'm asking a question of the witness.
So after a long series of questions and Rittenhouse's answers starting to slow, him starting to lose focus for being on the stand for multiple different hours, his attorney objects in a way that is not a legitimate objection. When he says objection, the guy had a gun in his hand, the intent in that is not to get the judge to actually agree with his objection, because that's ridiculous. We're talking about Kyle Rittenhouse's perception of him as a threat. Obviously, we know he had a gun in his hand. He's still allowed to ask the question, but this guy brings it up for a very specific reason, because it actually focuses Rittenhouse. His answers from this point on, talking about Grosskreutz, involve him having the gun in that hand.
And he's no threat to you at this moment, is he?
Objection, Your Honor. He's standing in front of him with a gun.
That's an argument you can make. I'm asking a question of the witness.
You can answer the question.
Yes.
He's no threat to you at this moment, is he?
He is a threat. He has a gun in his hand.
You saw that gun.
Yes.
So at the moment,
So this was a way for the defense. It was a clever maneuver. Give credit where credit is due. Slipped it by the judge. I noticed it on first watch, but if you watch the replay, it's even more slick of a maneuver, and one of the very few slick maneuvers by the defense for him to feed Kyle Rittenhouse an answer that he wants him to answer. This was good. This was good lawyering. He got away with it. It's not exactly the most ethical lawyering, but when you compare it to the prosecution, who's tried dirty, sly tricks the whole time and been called out for it, you can see the effect of when you need it, actually using it, and how you can get away with it if, again, you're not constantly at war with the judge.
Your Honor, I don't know what the state's going to do next, but I suspect that it's something along the lines of they're going to use the iPad, and Mr. Binger was talking about pinching the screen. iPads, which are made by Apple, have artificial intelligence in them that allow things to be viewed through 3 dimensions and logarithms. Logarithms, I don't understand it all either. And it uses artificial intelligence or their logarithms to create what they believe is happening. So this isn't actually enhanced video. This is Apple's iPad programming creating what it thinks is there, not what necessarily is there. And I don't know what's going to happen, but we had this video enhanced. We have testimony regarding it, and this is one of the topics that came up. I asked my expert. I said, do you know of anything that does something like that? Because that was when Detective Antaramian testified about pinching his telephone. And that's what I was told. And that's what I think this is going. And I don't think that it's appropriate. It's wrong.
Now, also very crucial, and it's almost as if it came at the same time that people who aren't lawyers, don't know anything about law, and just love complaining on Twitter were complaining that Kyle Rittenhouse's defense attorneys weren't objecting enough. They objected to a pinch to zoom feature on the iPad, and after looking into it, they're actually 100% right. When you pinch to zoom on your phones, it's actually artificially filling in what the computer thinks information should be to clarify the image, and this is clearly altering the image, and this led to a whole different hearing outside the purview of the jury. And basically, the defense won this objection unless the prosecution could produce an expert to say that the iPad wasn't doing what they claimed that they did. This was a great objection, and this is why the number of objections, it's not Law and Order Kids, we're not talking about TV shows, is not relevant. The quality of the objections are relevant. That's why I highlighted one that was actually baseless, but impacted his client's testimony, and one that was actually base. It actually had something to it that ended up preventing bad evidence from being introduced in this case. And you could always tell the losses on the prosecution's face and in their tone of voice, because again, as with their attitudes and not being able to hide that, they're also not capable of emotional discipline, and they're not able to hide their reactions to losing certain motions. Now, with all that being said, and I mean literally all that being said, I want to know what you guys thought about the testimony. What were moments that stuck out to you? Obviously, I didn't break down the whole entire thing, but I would like to hear your opinions. And do you think that this helped Kyle Rittenhouse? Do you think that this was neutral? Or you like me, where you think it didn't help him? It obviously hurt him, even if it's not very much. Let me know your thoughts, comments down below. If you liked the video, you show them by leaving a like. Subscribe for more content. Follow me on all my social media. Support me via the support links down in the description box. Follow me on my Instagram. It's new, and I want people to follow me. Till next time.